Hi, I'm Greg Gimeno from Chesapeake Wills and Trust, and today I'm going to talk to you about the most overlooked part of estate planning. So today we're going to talk about the most overlooked part of estate planning. But before we do that, don't forget, if you like this video, hit the like button. And if you want to be notified of other videos as we post them on our YouTube page, hit the subscribe button. And as always, leave comments down below. When I sit down and talk to someone about their estate plan, I always ask them, why are you here? What are you trying to do? What do you want to make sure you accomplish with your estate plan? And invariably, the answers I always get are, I want to make things easy on my kids when I pass away. I want to make sure this person gets this particular asset, or I want to make sure that I split things evenly amongst my kids. Or sometimes I want to make sure a certain person doesn't get any part of my estate. But estate planning is what I call a two-act play. Act number one is what happens to your stuff if you're alive but disabled. And act number two is where does your stuff go after your death? Everybody wants to talk to me about act two, where their stuff goes after their death. But nobody focuses on act number one, is who's going to manage your stuff upon your disability. So why is it so important to choose someone to manage your affairs if you can't? Well, if you don't pick someone to manage your affairs, the government will step in and they have a plan for you. So nobody ever wants to rely on the government's plan for you and your assets. So let's talk about why it's so important to plan. So let's say that mom is a widow. Now she's in the nursing home. She's disabled. There's no co-owner on her account. Her husband has predeceased her. And now, because of her physical or mental disabilities, she can't write checks on her account. She can't sell her house. She can't pay for her own care. So if mom has done no advanced planning, she's turning to the government for the plan for her. And the government's plan involves applying for guardianship at the courthouse. So in the state of Maryland, here's how the guardianship works. Mom is in the nursing home. She is what we call now an alleged disabled person. And now her kids, hopefully they can agree on who's going to apply for guardianship, has to go to the courthouse and submit a petition for guardianship. And along with that petition for guardianship, there's a filing fee that the court imposes. And you have to provide 2 physician certificates to show that mom is not capable to handling her own affairs. Now, it's not that simple. You don't just get to file paperwork and automatically get to manage mom's bank account or sell mom's assets to pay for her care. Here in Maryland, guardianship proceeding is what we call an adversarial proceeding. That means that mom, if she's able to speak and to communicate in the process, has the ability to contest the imposition of the guardianship. Because if a guardian is imposed, the person over whom the guardian is imposed is treated as they are an unemancipated child and lose all rights in their assets. So mom could contest the imposition of the guardianship. So mom gets a lawyer appointed for her. Now, mom's never met this lawyer, doesn't know whether she'd like the lawyer or not, can't assess that lawyer's credibility or whether it's a good lawyer or a bad lawyer. But mom now has a lawyer appointed for her in the guardianship proceeding. And guess who pays for that lawyer? That's right, mom pays for that lawyer. And that lawyer is there to do whatever mom says to do. So if mom says, I want you to contest this guardianship, well, then now we have a contested guardianship on our hands. And mom has the right to have her guardianship case heard in front of a jury. 6 of her peers, selected from the motor vehicle rolls of the county in which she resides, will make a decision about whether she's competent or not, and also who is going to be appointed as her guardian. So how do we avoid the government's plan for us? Well, the government's plan for you can be avoided by doing proper estate planning. That would be having a proper power of attorney that gives your power of attorney the ability to access your bank accounts, to sell your real estate, to cash in your stocks, to cash in your bonds, to pay for your care if you can't do it yourself. The other way that we can prevent a guardianship is through proper trust planning, creating a revocable living trust during your lifetime. And then you can say, I am in charge of my trust up until the point where I become disabled. And now I can select which child that I want to handle my assets, to manage my trust. Doing proper estate planning is the way to prevent the government's plan from being imposed on you. So there you have it. The most overlooked part of estate planning is failing to plan for Act 1 of the play. What happens if you're alive but disabled? Again, I'm Greg Gimeno with Chesapeake Wills and Trust, and thank you for watching our video. And if you're watching on our YouTube channel, check out the description down below, where you can order a free copy of my book, How to Protect Your Home and Life Savings in Maryland, and to register for one of our free online webinars.